NCLT proceedings as well as DRT proceedings, wherein the documentary evidence shows that the de facto complainant has actually in fact defrauded crores of rupees to Andhra Bank, and there is a standing order, a recovery proceeding order that has been issued by the magistrate of a court in Bengaluru against Namakirti's properties. In order to circumvent and stymie the entire controversy, he has chosen to file a criminal case on the petitioner in order to divert the attention from the real controversy, Your Honor. And in this regard, we are submitting and we are placing reliance on the following set of documents which may be marked as exhibits. The FIR in crime number 90 read with FIR 69 may be read conjointly. The second exhibit, set of exhibits that we choose to invite the attention of the Honorable Court is the credentials of the petitioner. Thirdly, the details of the company where the petitioner is the managing director and the de facto complainant in fact has been a director. His FIR, a mere look at the FIR copy, even a cursory look at the FIR copy would reveal that he is presenting himself as an agriculturist, which is a far-fetched suppression of the actual reality. We have produced the details from the Ministry of Corporate Affairs that invariably shows that the de facto complainant is actually a director of that said company. The fourth set of documents that we are furnishing to the Honorable Court would demonstrate that there is absolutely no prima facie case against the petitioner, even if one takes the statements on face value, whatever is alleged in the complaint, Your Honor. To attract the offences of either cheating or criminal breach of trust. The DRT proceedings, court orders, the legal scrutiny reports, certified copies of which are lying in the Honorable Courts, the SARFACI proceedings under the Debt Recovery Tribunal would actually show that the de facto complainant owes more than 57 crores of fraudulently obtained loan, that not only has he defaulted, but it also shows that he himself has alienated that property to several third parties. And there is a writ petition number 51227 of 2019 that is also pending in the Honorable High Court for the state of Karnataka at Bengaluru, Your Honor. The fifth set of documents that we are inviting the kind attention of the court for marking as exhibit would be the malicious prosecution which is being conducted by the local police. One is the letter dated 11th of November 2019, along with the details of the recent episode where they obtained a passport order from Karnataka. They traversed all the way to Telangana and whisked away with the vehicle, the said vehicle, which they have made an allegation of cheating. They have actually taken the vehicle without following due process of law, and the petitioner has got issued a notice and notified the higher ups in the police. Until date, there has been no response. The document dated 16th of November is a legal notice, Your Honor, which was issued upon the de facto complainant, calling upon him with all the set of facts that have been reiterated here and under. With this said, I would proceed to advance certain arguments by relying on certain Supreme Court citations. Firstly, I would, with the kind permission of the Honorable Court. This is on page number 26 of our written arguments in the court, where we are referring to the matter of Shamsher Singh Verma versus the state of Haryana, 2015 judgment by the Honorable Learned Justice Deepak Mishra Garu and Prafulla Pant, a bench of the Supreme Court, which provided an enunciation of the object of CRPC 294 CRPC to mark exhibits even in a trial court proceedings at any stage, Your Honor. I would also rely on the High Court judgment in the matter of Veerla Venkateswar Rao versus the state, represented by the public prosecutor, 2005 judgment, wherein the criminal rules of practice allow for marking of exhibits even at the stage of a trial or pre-trial phase. And now I would go into the expression of law for justifying the grant of anticipatory bail by placing reliance in the matter of Gurbakh Singh Sibia versus the state of Punjab, 1980, volume 2, SEC page number 565, wherein para 35, as your honor may have already taken judicial notice of, that section 438 subsection 1 of CRPC lays down a condition that the applicant must show that he has reasonable belief that there might be arrest for a non-bailable offense, and the ratio of the decision is that the anticipatory bail, Your Honor, is a device to secure the individual's liberty. And this is the ratio that we are relying on. Clearly, the facts of what has happened in the recent past would reveal that the local police of Bengaluru, Karnataka, having traveled all the way to Telangana, Hyderabad, took possession of a vehicle and even without following due process of law returned back, and making multiple forays itself creates a suspicion and fear in the mind of the petitioner who is apprehending arrest, that too in a falsely instituted case. And secondly, Your Lordship, the fourth point in para 35 states that, and I quote, anticipatory bail can be granted even after an FIR is filed as long as the applicant has not been arrested. We are satisfying all the conditions that have been laid out in the dicta of the Honorable Supreme Court. Again, in the matter of Ravindra Saxena versus the state of Rajasthan, 2010, volume 1, SEC page number 684, the bench of the Honorable Apex Court, speaking through the learned Tarun Chatterjee and Surinder Singh Nijar, paras 7, 8, 9 and 10 have actually held that where the core dispute between the complainant and the accused is in substance civil in nature, or it was a property dispute arising out of commercial transactions, the alleged offences attracting offences punishable 420, cheating, theft and so on, entitle the applicant for grant of anticipatory bail, and the rejection of anticipatory bail application by the Honorable High Court was set aside by the Supreme Court, Your Honor. Moreover, we are placing reliance on S.R. Tiwari versus the state Supreme Court judgment, wherein it was held by placing further reliance on other Supreme Court judgments that it was held that by placing reliance on Mahadev Prasad versus state of West Bengal, 1954 judgment, where the charge against the accused is under 420 is that he induced the complainant to part with his goods on the understanding that the accused would pay for the same but did not pay. If the accused had at that time he promised to pay cash, delivery of an intention to do so, the fact that he did not pay would not convert the transaction into one of cheating, Your Honor, which is pari materia to the facts of the present case. Here, there is not an iota of evidence which can demonstrate that a prima facie case exists against the applicant for anticipatory bail in this case, Your Honor. The documents were furnished by the de facto complainant to the bank, not to us. And that also it was done for allowing the grant of surety, for which he himself is one of the secondary beneficiaries. He is nominated as an additional director of the company at that set period of time. Moreover, Your Lordship may kindly take judicial notice of para 18, page number 30, in the matter of V.R. Dalal and others versus Yogendra Naranji Thakur and another 2008 volume 15 SEC on page 625, wherein again a bench of the Honorable Supreme Court, speaking through the learned S.B. Sinha and H.S. Bedi, have actually placed reliance on further Supreme Court judgments and made out that para 11, that where the dispute is purely civil in nature, an offence under 420 or section 120B of IPC cannot be said to be made out, and so on. Now, Your Honor, in the present matter at hand, it emerges that all disputes pertaining to the terms of agreement are solely covered and governed by civil nature of the alleged breach, if at all there is a breach, Your Honor. Secondly, no mens rea or guilty intention may be attributed to the defaulting party simply because there has been a baseless allegation made against the applicant here. Thirdly, Your Lordship, the list of documents that we have propounded at a bare minimum clearly and undeniably establishes that any averments regarding cheating or criminal breach of trust or otherwise has been superseded, and as a direct consequence, allegations by relying solely on the mere baseless allegations must be discarded. More so because the entire material facts regarding the a priori conduct of the de facto complainant has been suppressed. Thus, when the intention to deceive by the petitioner itself is in doubt, which is a key necessary ingredient to establish cheating in the present case at hand, it would be highly prejudicial to the cause of the petitioner by arrest or continuous lockup, which can be averted by the grant of this anticipatory bail, Your Lordship. Furthermore, I seek the kind indulgence of the court to place reliance on Siddharam Saddilikappa Matre versus the State of Maharashtra, 2011, volume 1 SEC, page 694, para 116, as well as para 122, 123 and 124, which can be ratio-signated that personal liberty is a very precious fundamental right and it should be curtailed only when it becomes imperative according to the peculiar facts of the case, Your Honor. And this classic citation has been followed in a catena of High Court judgments. One of the most recent being in the matter of M. Nagaraju versus the state. And the other aspect which I would propound and then finally conclude my argument would be placing reliance in the matter of Rakesh Baban Borhade versus the state of Maharashtra and another 2015 judgment, volume 2 SEC, page number 313, wherein on para 10 it has been held that where disputed questions of facts have been involved, this scenario deserves the grant of anticipatory bail, para 10. Furthermore, the court may also consider the dicta of the Honorable Apex Court in the matter of Prahalad Singh Bhati versus the National Capital Territory region of Delhi, 2001, volume 4 SEC, page 280, para 8, Your Lordship, that the jurisdiction to grant bail has to be exercised on well-settled principles, and it is not expected at this stage, at the stage of anticipatory bail, to allow the prosecution to start having and providing evidence establishing the guilt of the accused beyond reasonable doubt, Your Honor. Thus, with this said, I respectfully pray that this Honorable Court may allow this anticipatory bail, particularly given the fact that the nature of allegations, the nature of evidence in support thereof, everything shows that there is absolutely no prima facie case against the accused. We are willing to comply with any and all conditions imposed by this Honorable Court. We are submitting to the jurat of this court to do justice. This is not a crime which attracts a life imprisonment or any possibility of tampering with witnesses or destruction of evidence. In fact, we are providing more evidence than what is actually on the record of the prosecution to actually show that this is a falsely instituted crime, and given the grave threat of arrest to the petitioner and his life and property that stands at unfathomable risk, we respectfully pray that the present petition granting anticipatory bail to the petitioner should be allowed. We are seeking the kind indulgence of the court to pass any other such orders as it may deem fit in the interest of justice. Much obliged, Your Lordship. I rest my case.